Without giving specific legal advice, I can say that when a company is facing an arbitration regarding a securities-related claim or allegation, the first thing I would do is I'd protect all the data that's out there. So I would freeze all the data or electronically stored information and sequester it in a place where the chain of custody is not interrupted, to make sure that nothing is deleted, because you could have some important information there that is important to a claim or a defense, and the business should maintain that. The second thing I do is I would seek excellent counsel to advise the business owner further about what an arbitration means, the consequences of an arbitration, selecting an arbitrator and that whole process, which is, you could write books about that because it's an interesting science. And then how to proceed with prosecuting or defending an allegation. And arbitration is unique because it's a formal process, but it also has some expedited dynamics. It also depends on the type of forum you're in, whether it's before the AAA or JAMS or FINRA. So there's a lot of analysis and decision making that needs to happen. And that's why an important relationship between the CEO and her or his legal advisor is critical. Deciding whether or not to go into an arbitration proceeding or opt out of an arbitration proceeding and attempting to prosecute a claim in state court or defend a claim in state court or federal court or any court for that matter, that's an important, critical decision. And that should be analyzed in turn with your legal advisor. And there's a lot of different factors to consider. And some of those factors, without being exhaustive or without providing specific advice, would be, for example, the nature of the claim and whether or not the forum would be friendly to that claim. There's a connotation that defense claims are better for arbitration because arbitrators are more conservative than juries, for example. There's also a connotation that going to court in lieu of arbitration would be more expensive and time-consuming than an arbitration. There's another stereotype that arbitrators are more intelligent triers of fact than juries. That's not always the case. So there's some very specific analysis and decision making that needs to be done. That should be done in turn with your legal advisor. And in my experience, when I've had to face that with a client, it's a long process because you're deciding all the consequences that arise out of going to arbitration or trying to resist or not going to arbitration, and then figuring out what to do in light of that analysis. With respect to handling securities cases in arbitration, the one area that I think there could be improvement is the speed of getting arbitrations set on calendar and expediting those arbitrations. The whole purpose of arbitration is to have a neutral fact finder render a decision quickly, expediently, and as cost effectively as possible. And while that's generally true that arbitrations are faster than court proceedings, sometimes arbitrations can get bogged down because of scheduling issues or cost issues. In my view, if there was a way to expedite that process as much as possible, I think that benefits all parties, whether it's the defendant or the plaintiff in that type of a case.